Uh, in the situation of somewhere like the YMCA or like the Salvation Army, any sort of homeless shelter, some cases have held, and this is sort of across the nation, that long-term residency through a charitable program does not create a landlord-tenant relationship. So that's in a lot of different places. There's cases from Michigan and from Ohio, and I've cited some of those down there that apply that. But the YMCA was not a transient occupancy. So it sort of depends. South Carolina law, though, specifically accepts residents, whether temporary or not, at a charitable or emergency protective shelter, private or public, from the Residential Landlord-Tenant Act. So people in those situations, the law is very clear, do not apply and are not protected by the Landlord-Tenant Act when it comes to an eviction. And that's going to be any sort of public shelter. It's going to be any private church shelter, anything funded in those sort of ways. And from my experience, I think that a lot of those providers are usually very, very clear about the spaces that they are letting people stay in. Usually they are very clear that you are not entering into a landlord-tenant agreement, and they may have different requirements. It could be treatment programs, it could be all sorts of things that they require for people to stay in those charitable or emergency shelters. It just sort of depends. But for the most part, people and providers are very clear about those situations.